Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today is Sunday, 19 July, 2026, years after Jesus. It's after church. We're in the afternoon. It's after my office hours. No one ever comes to my office hours anymore, but that's okay. Less for me to do. Actually, I always keep myself busy with administrative stuff anyway. We have Bostock versus Clayton County, Georgia. We're working our way through the rest of it, and we're going to continue from where we left off on February 28th, 2025, with Kavanaugh's dissent. And I'm going to share my screen. Feel free to call me Sharon. We were on page 6 of the Kavanaugh dissent, and I think I had it at 220% there. It's pretty easy to find. You just search Bostock versus Clayton County 2020. And as you recall, it bills itself as a statutory construction Supreme Court decision interpreting the 1964 Civil Rights Act to some cases, applying that to some cases involving so-called transgender status in the employment context and sexual orientation. And recall, Justice Kavanaugh's writing in dissent. We've already taken a look at Justice Alito's dissent, and we're working our way through this. As you recall, Justice Gorsuch wrote the court opinion in this case, and he got the wrong answer. He got the wrong answer on the interpretation of the 1964 Civil Rights Act. And, Justice Kavanaugh, as he is known for doing, sees a constitutional issue here in terms of separation of powers. Justice Kavanaugh says famously that every case is a constitutional law case in the sense, and at least in the federal case, federal sense, because of Article 3 in the Constitution, which specifies the vesting clause of the judicial power. The judicial power involves a judicial duty to say what the law is, but the duty is also to restrict judges to their proper role. And so that's why every case is a constitutional law case in the sense that every case is a separation of powers case because it involves the power and duty of judging. Now, on the bottom page 6 of Kavanaugh's dissent, he says, judges adhere to ordinary meaning for two main reasons. Now, recall, you're going to want to go back to the 28 Feb episode and watch the last part of that because we're picking right up. We're not going to waste a lot of time redescribing everything. That's why we have separate episodes, right? This is 19 July 2026 episode. Okay. So this is a distinction between ordinary meaning and what he calls literal meaning. Ordinary meaning and literal meaning. Judges adhere to ordinary meaning for two main reasons: rule of law and democratic accountability. Okay. This is a restriction on the judges. This is part of the duty of judging. A society governed by the rule of law must have laws that are known and understandable to the citizenry. And judicial adherence to ordinary meaning facilitates the democratic accountability of America's elected representatives for the laws they enact. We're on the top of page 7, Kavanaugh dissenting, in 590 U.S. This is the slip opinion, okay? Is it in the volume yet? I haven't seen it, but then again, I haven't been in the law library and picked it up, so maybe it's there, maybe it's not. Citizens and legislatures must be able to ascertain the law by reading the words of the statute. Both the rule of law and democratic accountability badly suffer when a court adopts a hidden or obscure interpretation of the law and not its ordinary meaning. Consider a simple example of how ordinary meaning differs from literal meaning. Okay, listen to the difference. He's saying ordinary, good, ordinary meaning, that's normal, normative, literal meaning, not normative. A statutory ban on vehicles in the park, Kavanaugh continues on page 7, would literally encompass a baby stroller. Now notice this is a reductio ad absurdum form of argument. Can we have a statutory ban on vehicles in the park? Yes, but then that would encompass baby strollers if you took that literally. And that's absurd. That's an absurd result. So therefore, to avoid this absurd result, you must reject what led to the absurdity, which is not the language of the rule, but the interpretation of the rule, which would be literal. So he's saying literal interpretation leads to absurdities. It's called a reductio ad absurdum form of argument. But no good judge would interpret the statute that way because the word vehicle in its ordinary meaning does not encompass baby strollers. The ordinary meaning principle is long-standing and well settled. Time and again, this court has rejected literalism in favor of ordinary meaning. Take a few examples. These are bullet points on page 7. The court recognized that beans may be seeds in the language of botany or natural history, but concluded that beans are not seeds in commerce or in common parlance. That's from a 1889 case, Robertson versus Solomon. Second bullet point. The court explained that tomatoes are literally the fruit of the vine, but in common language of the people, tomatoes are vegetables. That's from 1893, Nix versus Hedden. Third bullet point, the court stated that the statutory term vehicle does not cover an aircraft. No doubt, etymologically, it is possible to use the word to signify a conveyance working on land, water, or air, but in everyday speech, vehicle calls up the picture of a thing moving on land. That's from 1931, McBoyle versus United States. Fourth bullet point, the court pointed out that this court's interpretation of the three-judge court statutes has frequently deviated from the path of literalism. Okay, that's from 1974, Gonzalez versus Automatic Employee Credit Union. Okay. Fifth bullet point on page 8 at the top. Kavanaugh dissenting, Bostock versus Clayton County, Georgia, 2020. The court refused a reading of mineral deposits that include water, even if water is a mineral in the broadest sense of the word, because it would bring about a major alteration in established legal relationships based on nothing more than an overly literal reading of a statute without any regard for its context or history. 1978, Andrus versus Charleston Stone Products Company. Okay, the next bullet point. The court declined to interpret facilitating a drug distribution crime in a way that would cover purchasing drugs because the literal sweep of facilitate sits uncomfortably with common usage. That's 2009. Abuhala versus United States. The next bullet point. The court rebuffed a literal reading of personnel rules that would encompass any rules that personnel must follow, as opposed to human resources rules about personnel, and stated that no one using ordinary language would describe personnel rules in this manner. That's from 2011, Milner versus Department of the Navy. The court explained, this is the next bullet point, and this is the last one in this series. The court explained that when construing statutory phrases such as arising from, it avoids uncritical literalism leading to results that no sensible person could have intended. That's from 2018, plurality opinion. Jennings versus Rodriguez. Kavanaugh continues, those cases exemplify a deeply rooted principle. When there's a divide between the literal meaning and the ordinary meaning, courts must follow the ordinary meaning. Next is a critical point of emphasis in this case. The difference between literal and ordinary meaning becomes especially important when, as in this case, judges consider phrases in statutes. Recall that the shorthand version of a phrase at issue here is, quote, discriminate because of sex, unquote. The full phrasing of the statute, I'm looking at footnote 3. The full phrasing of the statute is provided in footnote 2. Let me look up at footnote 2. Scrolling up. Okay, footnote 2 is on his page 3 of the dissent. So I'm shining footnote 2. It's quite long. Well, it's longer than I want to read, put it that way. But you could read that. All right. So you can check that out on your own. Discrimination because of sex. That's the phrase. So the question here is, do you interpret it literally or in the ordinary meaning? And he's saying it's normative to use the ordinary meaning, but Gorsuch makes a mistake applying literal interpretation, which, if it was consistently adopted as proper statutory construction, would involve reductio ad absurdum, reducing to absurdity. Page 9 at the top. Courts must heed the ordinary meaning of the phrase as a whole, not just the meaning of words in the phrase. That is because a phrase may have a more precise or confined meaning than the literal meaning of the individual words in a phrase. Examples abound. An American flag could literally encompass a flag made in America, but in common parlance, it denotes the stars and stripes. A three-pointer could literally include a field goal in football, but in common parlance, it is a shot from behind the arc in basketball. A Cold War could literally mean any wintertime war, but in common parlance, it signifies a conflict short of open warfare. A washing machine could literally refer to any machine used for washing any item, but in everyday speech, it means a machine for washing clothes. This court has often emphasized the importance of sticking to the ordinary meaning of a phrase rather than the meaning of words in the phrase. In FCC versus AT&T Incorporated, that's at 562 U.S. 397 at year 2011, for example, the court explained, quote, AT&T's argument treats the term personal privacy as simply the sum of its two words, the privacy of a person, but two words together may assume a more particular meaning than those words in isolation. Now, that's a key idea there. Two words together may assume a more particular meaning than those two words in isolation. We understand a golden cup to be a cup made or resembling gold. A golden boy, on the other hand, is one who is charming, lucky, and talented. A golden opportunity is one not to be missed. Personal in the phrase personal privacy conveys more than just of a person. It suggests a type of privacy evocative of human concerns, not the sort usually associated with an entity, say, like say AT&T. That's quoting page 406. That's pretty good. I like that. Page 10 at the top. Exactly right and exactly on point in this case. Justice Scalia explained the extraordinary importance of hewing to the ordinary meaning of a phrase. Quote, adhering to the fair meaning of the text, the textualist touchstone, does not limit one to the hyperliteral meaning of each word in the text. In the words of Learned Hand, a sterile literalism loses sight of the forest for the trees. The full body of a text contains implications that can alter the literal meaning of words, unquote. That's from Scalia and Garner, Reading Law, 2012. Put another way, Kavanaugh continues, the meaning of a sentence may be more than that of the separate words, as a melody is more than the notes. Judges must take care to follow ordinary meaning when two words combine to produce a meaning that is not the mechanical composition of the two words separately. Dictionaries are not always useful for determining the ordinary meaning of word clusters, like driving a vehicle, or phrases and clauses or entire sentences. And we must recognize that a phrase can cover a dramatically smaller category than either component term. Very good, very good. Because this is about the smaller category, cutting down a more particular meaning than words in isolation taken by themselves would suggest. Okay. If the usual evidence indicates that a statutory phrase bears an ordinary meaning different from the literal strung together definitions of individual words in a phrase, we may not ignore or gloss over that discrepancy. Yeah. Legislation, I'm not always doing the quote and unquote because it gets a little clunky. Legislation cannot sensibly be interpreted by stringing together dictionary synonyms of each word and proclaiming that if the right example of the meaning of each is selected, the plain meaning of the statute leads to a particular result. No theory of interpretation, including textualism itself, is premised on such an approach. He was quoting somebody there in a lower court. Okay, now, page 11. In other words, this court's precedents and long-standing principles of statutory interpretations teach a clear lesson. Do not simply split statutory phrases into their component words, look up each in a dictionary, and then mechanically put them together again as the majority opinion today mistakenly does. To reiterate Justice Scalia's caution, that approach misses the forest for the trees. A literalist approach to interpreting phrases disrespects ordinary meaning and deprives the citizenry of fair notice of what the law is. Now, this is a separate point from the reductio ad absurdum interpretive point, which is a hermeneutical point. Here, Justice Kavanaugh is going to the justice of the issue, the natural law morality of the issue, by invoking due process concerns. You don't have what is substantively required, that is by the natural law, the obligations that the very nature of morality imposes on the government. Okay. The process that is due you as someone created in the image of God, which goes back to the founding document, the Declaration of Independence. Yeah. Right. Due process requires something called fair notice of what the law is. Right. How do you take precautions to be compliant with the law if you don't know what it is ahead of time? And how can you be held responsible for not complying with the law if you didn't know ahead of time so that you could order your affairs accordingly, right? A literalist approach to interpreting phrases disrespects ordinary meaning and deprives the citizenry of fair notice of what the law is. It destabilizes the rule of law and thwarts democratic accountability. For phrases as well as terms, the linchpin of statutory interpretation is ordinary meaning, for that is going to be most accessible to the citizenry desirous of following the law and to the legislatures and their staffs in drafting the legal terms of the plans launched by statutes, and to the administrators and judges implementing the statutory plan. Makes sense to me. Bottom line, Statutory Interpretation 101 instructs courts to follow ordinary meaning, not literal meaning, and to adhere to the ordinary meaning of phrases, not just the meaning of the words in a phrase. Second, in light of the bedrock principle that we must adhere to the ordinary meaning of a phrase, the question in this case boils down to the ordinary meaning of the phrase, quote, discrimination because of sex, unquote. Does the ordinary meaning of that phrase encompass discrimination because of sexual orientation? The answer is plainly no. Page 12 at the top. On occasion, it can be difficult for judges to assess ordinary meaning, not here. Both common parlance and common legal usage treat sex discrimination and sexual orientation discrimination as two distinct categories of discrimination back in 1964 and still today. Okay, so what's his evidence of that? We're going to get to the evidence of that as soon as I get a drink of water. All right, now let's get to his evidence for that. As to common parlance, Kavanaugh continues on the top of page 12. Few in 1964 or today would describe a firing because of sexual orientation as a firing because of sex. As commonly understood, sexual orientation discrimination is distinct from and not a form of sex discrimination. The majority opinion acknowledges the common understanding, noting that the plaintiffs here probably did not tell their friends they were being fired because of their sex. That observation is clearly correct. In common parlance, Bostock and Zarda were fired because they were homosexual, not because they were men. You know, that's very powerful to me. Let me look at my notes really quick. Yeah. Okay, I want to model how to do this for you because I print it out. And yeah, I mean, you don't have to have a cigar. I oftentimes have one. Um, yeah, that's a very powerful point. Now, let's continue. Looks like I'm actually keeping track with my comments that I made. The comments I made on this go back to a while ago. Looks like I made these comments on 26 February 2020, my grandpa's 103rd birthday. Okay. Contrary to the majority opinions approach today, this court, now this is why it's interesting politically, because you have two Trump appointments on either side here. Okay. It makes it very difficult to tell what the Republican position is supposed to be on this because you've got Trump on one side, you got Trump on the other. You've got Bush on the one side, you got Bush on the other. So what the heck, Kramer, what's going on here? You know what I mean? Remember, this is before Barrett came on the court. Barrett came on late 2020. This is in the middle of 2020, back when all the craziness was. And maybe you can chalk up Gorsuch's crazy majority opinion to all the craziness that was going on in the world at that time. I don't think you can, but uh, it's tempting to say that, right? Okay, let's continue now. Okay, uh, so contrary to the Trump majority opinion, this Trump dissent, so you can see that I'm taking a side here for the Republicans. Contrary to the majority opinion's approach today, this court has repeatedly emphasized that common parlance matters in assessing the ordinary meaning of a statute because courts heed how most people would have understood the text of a statute when enacted. Okay. Consider the employer who has 4 employees but must fire 2 of them for financial reasons. Suppose the 4 employees are a straight man, a straight woman, a crooked man, and a crooked woman. So you got 2 straight and 2 crooked. I don't like this language of straight and crooked. Come on, straight? Give me a break. Heterosexual. Can I just use that word? The 4 employees are a heterosexual man, a heterosexual woman. By the way, we know what those words mean, okay? A homosexual man and a homosexual woman. He uses straight man, straight woman, gay man, and lesbian. I'm just going to use heterosexual. I'm going to use the term that as it occurs in the classical literature involving the word sex, okay? Now, sexual orientation involves that 3-letter word. That's why I use sexual orientation, heterosexual, homosexual. I just think it's clear. I think the other language is weird and confusing. So now the employer with animosity against women, animosity based on sex, will fire the 2 women. The employer with animosity against homosexuals, animosity based on sexual orientation, will fire the homosexual man and the homosexual woman. Those are 2 distinct harms caused by 2 distinct biases that have 2 different outcomes. To treat one as a form of the other, as the majority opinion does, misapprehends common language, human psychology, and real life. Page 13 at the top. Yeah, now this next point, I think this next point may be the most important point that he makes. It also rewrites history. It also rewrites history. I don't like it when people try to rewrite history. That's what communists do. That's what communists do. I don't like it. Seneca Falls was not Stonewall. Man, the women's rights movement was not and is not the homosexual rights movement, although many people obviously support or participate in both. So to think that sexual orientation discrimination is just a form of sex discrimination is not just a mistake. It's not just a mistake of language and psychology, but also a mistake of history. I really think this is important. It's a mistake of history and sociology. I don't think you need to say the word sociology there, but okay. History. Importantly, an overwhelming body of federal law reflects and reinforces the ordinary meaning and demonstrates that sexual orientation discrimination is distinct from and not a form of sex discrimination. I agree. I'm going to take a drink of water for a sec. Yeah. This issue of history is really important. Since enacting Title VII in 1964, Congress has never treated sexual orientation discrimination the same as or as a form of sex discrimination. Instead, Congress has consistently treated sex discrimination and sexual orientation discrimination as legally distinct categories of discrimination. There's the separation of powers angle there. Separation of powers protects individual liberty. So he's saying, let's take a look at what Congress understands is going on. Congress is a separate power over there. We need to respect how they do things as long as they stay in their lane and they do things correctly in terms of our constitutional system. Okay. As long as they're coloring within the lines. Now, many federal statutes, in other words, these are results that are widely accepted as Congress coloring within the lines here. Many federal statutes prohibit sex discrimination, and many federal statutes also prohibit sexual orientation discrimination. But those sexual orientation statutes expressly prohibit sexual orientation discrimination in addition to expressly prohibiting sex discrimination. Every single one. Every single one. To this day, Congress has never defined sex discrimination to encompass sexual orientation discrimination. Instead, when Congress wants to prohibit sexual orientation discrimination, in addition to sex discrimination, Congress explicitly refers to sexual orientation discrimination. And he's got a very detailed footnote there, page 14 at the top. That long-standing and widespread congressional practice matters. When interpreting statutes, as the court has often said, we usually presume differences in language convey differences in meaning. When Congress chooses distinct phrases to accomplish distinct purposes and does so over and over again for decades, we may not lightly toss aside all of Congress's carefree handiwork. As Justice Scalia explained for the court, it is not our function to treat alike subjects that different Congresses have chosen to treat differently. And the court has likewise stressed that we may not read a specific concept into general words when precise language in other statutes reveals that Congress knew how to identify that concept. Okay. More details in the footnote, page 15 at the top. So it is here. As demonstrated by all of the statutes covering sexual orientation discrimination, Congress knows how to prohibit sexual orientation discrimination. So courts should not read that specific concept into the general words discriminate because of sex. We cannot close our eyes to the indisputable fact that Congress, for several decades in a large number of statutes, has identified sex discrimination and sexual orientation discrimination as two distinct categories. Where possible, we also strive to interpret statutes so as not to create undue surplusage. It is not uncommon to find some scattered redundancies in statutes, but reading sex discrimination to encompass sexual orientation discrimination would cast aside as surplusage the numerous references to sexual orientation discrimination sprinkled throughout the U.S. Code in laws enacted over the last 25 years. And I think I think what he's doing here is another reductio ad absurdum form of argument here. He's saying all those Congress members who gave themselves high fives for protecting homosexuals by getting those little amendments passed through into law, protecting individuals in various ways in federal law against sexual orientation discrimination. Well, all of that would be ridiculous and be um, not an accomplishment at all if the majority opinion is right, if Gorsuch is right. Because according to Gorsuch, those individuals were already protected. So what are you doing giving yourself a high five for doing it? Because they did it back in 1964, you idiot. And see, that's an absurd result because if you know the history, nobody in 1964 had on their radar protecting individuals from sexual orientation discrimination. And so those Congress members that senators and House members that worked to get those amendments passed into law that Justice Kavanaugh just referred to. It's understandable that they think of that as an accomplishment, as a legislative accomplishment that they could brag about and, run for reelection based on. Um, Now you might not agree with the result, like the legislative result, but that's a separate point than whether they did actually accomplish that legislative result. In other words, resulting in law that didn't exist before, as opposed to surplusage. Okay. I think that's a pretty powerful point. In short, an extensive body of federal law both reflects and reinforces the widespread understanding that sexual orientation discrimination is distinct from and not a form of sex discrimination. And we're going to stop there because I got to go have a cigar with Vernon at 888. We got a cigar club with the church. Of course, I work for the church, and Vernon is a parishioner, and my main man, Vern gets me into 888 because I don't have a, I'm too poor to get in. I don't get paid that much. Um, I do a lot for the church, but they don't pay me very much at all. Um, Now, one of the things I like to do with Christians is smoke cigars. And so what we do is we hang out with non-Christians and we have conversations about politics, about culture, about sports. I suck at talking about sports, but I watch people talk about sports and whatever comes up. We do talk about theology quite a bit. But anyway, we're going to go to it's just down the street from the church. So it's kind of fun. You can walk to the church. And I'm going to go meet Vern. So I got a cigar for him. I bring a cigar for Vern so that he can feel like I appreciate the fact that he pays the dues for this club. So where I can, if I have a cigar laying around, an extra one, I give it to Vern as an appreciation. Uh yeah, so please send me send me cigars, send me money for cigars because I pay it forward and it's for these kind of conversations in California. Ministry conversations, and if you want to send a donation for that, it will be used for that. You can send it to Venmo at the Republican Professor, all one word, at the Republican Professor. It's my name, Lucas Mather, and it's a it's a personal Venmo account, but I'll use that gift. It's not tax deductible. I will use it. Now, eventually I will use it for this kind of conversation in California, this kind of ministry conversation with and without with Christians and non-Christians. And you know what? A lot of people that are blessed by these conversations are Christians, actually. because it strengthens the faith. It strengthens the understanding of how the faith is supposed to interact with culture and to some extent um our history, you know, which includes, the legal history, how things went in the past, and what would be appropriate for the present in terms of how to interact with that, and just moving the ball forward in people's understanding, clearing up misconceptions of the gospel, and so on and so forth. So if you want to send a donation, I will funnel it over to Cigar Page, or you could just send cigars if you want. But I like to pick them out because I'm kind of picky at this point. I don't spend a lot on each cigar. If it's more than $4 for a cigar, I'm usually in the $4 range at Cigar Page. So anyway, I get them on sale. I get them on deep discount. Usually they're 20 75% off. That kind of deep discount. Like a $16 cigar at a cigar shop, I would pay $4 for. So anyway, but I know a lot of people are not into cigars, and I understand that, but it's a really good thing for men, especially. Um, some women, I think too, but mostly for men, I would say that it's just it can be a really special time, and it's hard to understand that. Um, it's kind of like the shooting sports too. Like if you're going to shoot skeet, some cigar clubs do shoot skeet while they're doing it, but we would not do that because, well, there's cultural differences with Christians, and a lot of people don't have a background with firearm safety. And in any case, I like to have a little bit of uh, bourbon or something, a little bit, just to sip while you're having the cigar. Um, and you can't do that when you have firearms involved at all. So, may you know what? Maybe what they do is they don't smoke them while they're shooting skeet. Maybe I have that wrong. I've never actually been to one of these things. There's one in Escondido that does this. It's a group called Holy Smokes. You can look them up on Facebook, Holy Smokes. Wherever you are in the country, there's a chapter of Holy Smokes, probably. Now, I don't know about every single part of the United States, but I know we have a pretty good one here in Orange County. All right, guys, take care. God bless you guys. It's 19 July 2026, years after Jesus. It's a Sunday. It's after church. It's in the afternoon. I told Vern I was going to be there about 15 minutes ago, so I got to get going. I got to go find his cigar. I think it's over there somewhere. God bless you guys.